Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. It is Thursday, 1 May 2025, and I have a question for you. Is there such a thing as the Uni-Party or a Uni-Party? Is there such a thing as a Uni-Party? Have you heard this term before? If so, what do you think it means? I've heard this term before by some of people that I would call black-pilled. These are people that don't think that any progress can be made in politics and culture. Um, and I think that I think it's more complicated than that. I think progress can be made, and that is an uncomfortable answer because it puts responsibility on you. It puts responsibility on me. It puts responsibility on us. Because if progress cannot be made, well, then uh, we're just going to sit around and smell the roses and, maybe have a few beers, depending on where you're at, shoot off a few rounds, hopefully not while you're having beers or any kind of alcohol. But you know the drill. Um, I think that progress can be made, and so I do, for reasons I'm not going to get into on this episode, think that progress can be made. I I eschew the black pill approach to culture and politics. Um, But there's another reason why I'm skeptical about the Uni-Party thesis. Not only does it support a black-pilled kind of approach to culture and politics, um, it's undermined by some other obvious things that we see. For example, this is the biggest piece of evidence, I think, against a so-called Uni-Party. And that is, well, look at the opposition to the first 100 days of Trump's presidency in the second term. He just finished 100 days today. This is the 100 days. So, I mean, look at the opposition to Brett Kavanaugh, for example. And I mean, if you need like a refresher on this or reminder or whatever, just look up Case in Point. It's a podcast put out by Heritage. Go back to 2018 and start at the beginning of the summer before Kennedy retired and just listen to those episodes. Listen to those dozen episodes during the Kavanaugh thing. Pick up Carrie Severino's book, Justice on Trial. Now, I mean, if you're black pilled, you're not going to pick up a book because pill people typically don't read nonfiction. But if you're interested in podcasts, just take a listen. I have I have something I want to play for you from Judge Bybee on the Ninth Circuit. Judge Beebe's been on the Ninth Circuit for over 20 years. He was put on the Ninth Circuit by George W. Bush. He's retired now. He took senior status, which all that means is you get paid the same, but you don't have to work. You can work when you want to. You can volunteer to do some work. Keeps you busy, keeps your mind active. To me, he doesn't look like he's retired. He looks pretty young, but he is senior status, and he's on the Ninth Circuit, and he's speaking at a Federalist Society event. And this Federalist Society event, I'm pulling it up on YouTube, I'm sharing my screen, was 2 weeks ago. It was April 16th, 2025. Federalist Society. I want to thank Federalist Society for the permission to use this clip. Of course, we're in the fair use of it. It's nonprofit. What we're doing, it's for educational purposes. We're only using a small portion of it, and we're doing a transformative reading and use of it because he's going to go through and he's going to give you 10 cases in Supreme Court precedent that Republicans would like to have overturned. And then he's going to give you 10 cases in that Democrats would prefer to be overturned. Now, if there was a uni-party, why would they be different cases? This is an embarrassing episode for me to have to make because I'm pointing out the obvious to you. In some respects, it might look from time to time like there is a so-called uni-party on some respects, but you got to go deeper and you have to not ignore the obvious. Okay. So here's Judge Bybee. Well, that's not Judge Bybee. Hold up. Y'all hold up. Here's Judge Bybee. If I can find it. Looks like I forgot to hit the escape button here. All right, guys. Okay, we got a question coming through the chat. Judge Bybee's last name is Bybee, and he's a Mormon. And so this is Federalist Society 2 weeks ago, April 16th, 2025. It's called Changes in the Role of the Judiciary Restraint versus Activism. And here he is on the left here, my left. And in the middle here is Robert Luther, who worked with Don McGahn, getting Trump's appointments to the judiciary through the first term. Adam Feldman, who is he's like an empirical judicial behavior kind of a guy. And then Judge Bumate. I said Bumate last time a couple times. I'm sorry, Judge, if you see this. Patrick Bumate is a Ninth Circuit judge, and we're going through his dissent in Duncan versus Bonta. Excellent. But we're at the 44-minute and 23-second mark. That's 44:23 on YouTube. And let's just listen a little bit to Judge Bybee, and then I have some comments. We're going to do a fair use of this material, but I want to thank the Federal Society for making this available for us. Thank you. All right, here we go. Changes in the role of the judiciary, restraint versus activism. He's got 10 cases he's going to go through that Republicans want to overturn, and then 10 that the Democrats. And you want to notice they're not the same cases. They're not even the same topic sometimes.
Be a pendulum swing back. So as I read these cases off, I'm going to invite you to imagine the consequences, legal, political, and practical, of overruling these decisions. And I'm going to ask you to also consider what happens if the next generation or the pendulum swing decides then to overrule these cases again. So I'll start with the cases I think the conservatives might wish to see overturned. At the top of the list, the easiest one right now is Humphrey's executor. This one has been in the court site for some time. You don't have to be the oracle at Delphi to see that the court is ready to reduce the scope of Humphrey's executor, even if it will not outright overrule it. That, of course, will have enormous consequences for the independent regulatory agencies. Most of those end with a C. And it is quite possible that if the court actually overrules Humphrey's executor, that Congress will respond by making substantial changes in the organization of those agencies and make them single-headed agencies or fold them into existing executive agencies. A second one that the...
All right, did you get that? Humphrey's executor. That was during FDR. It was during the New Deal, and it involved whether FDR had the power to fire a so-called independent agency commissioner. Humphrey's executor. that the guy was Humphrey. He died. His estate was the one that was suing. That's why it's called Humphrey's executor. Okay, let's keep going. There's the first one that Republicans would like to overturn.
Court didn't take up this last week would be Kelo. That's a takings clause. This would be a much more modest change, but it certainly is one that conservatives would like to have in their sights. The big one on this list.
Okay, Kelo, which is a takings clause case, which means it's about private property versus the government, the power of eminent domain. We talked about this when we did 40th anniversary of Richard Epstein's book called Takings, published in 1985. The third one, here we go, that Republicans would like to overturn.
One that academics on both sides of the aisle often regard as deeply infirm would be Slaughterhouse. And the implications of overruling Slaughterhouse are a thing to behold. If the court were to reinterpret what the court did in Slaughterhouse, reread Section 1 of the 14th Amendment, and reinvigorate the Privileges or Immunities Clause, the clause that clearly was intended to do all the heavy lifting of Section 1. It would diminish the role of the Equal Protection Clause and the Due Process Clause, which were both utilized, and I use that term very carefully, they were utilized by the court to accomplish what they thought the 14th Amendment was supposed to do, but without the benefit of the Privileges or Immunities Clause.
Okay. Slaughterhouse cases is a case just after the Civil War, and it's a 5-4 decision. I think it's one of the best cases to really study. I was required to read it and really study it when I took constitutional law for my Ph.D. in public law. Michael Uhlman taught that course. Fantastic books about Slaughterhouse, by the way. I could recommend some later when we talk about it, but let's keep going. Again, these are 10 cases that Republicans would like to overturn, according to Judge Bybee. And remember, the whole point of this exercise is the question, is there a Uni-Party or not? Keep going. Here's number 4.
There are a lot of consequences that would follow from that. It would, for example, threaten Bowling versus Sharp, the application of the equal protection principle to the federal government, and take down cases such as Adirond. So the consequences really would be far-ranging as the court had to restructure the 14th Amendment. The fourth case on my list is Blaisdell. That's the Minnesota mortgage moratorium case from the Great Depression era. The contracts clause was the most litigated provision of the 19th century, and the court really read it out, as Justice Sutherland points out in his dissent. He's clearly right. The court just read the contracts clause out of the Constitution. It read it out of the Constitution, and then it took a clause that applied to the states and applied it, reverse incorporated it against the federal government. So if the court were to overrule Blaisdell, it would have two consequences. One, it would reinvigorate a contracts clause against the states, and two, the court would have to revisit whether there are any principles that constrain the federal government. So it works on both sides. Number 5 on my list.
All right, so Blaisdell, that's the fourth case that he mentioned that Republicans would like to overturn. That he said that case mistakenly read the contracts clause out of the Constitution. Did you hear that? And he said Sutherland's dissent was correct. Sutherland was Republican. Sutherland was at one point the Republican nominee for President of the United States. So if you think I'm just making up he's Republican, no, he's not. I'm not making this up. It's clear as a bell he's a Republican. Not only that he was appointed by a Republican president, but I mean that's typically what I mean by Republican versus Democrat judges. But so we have the contracts clauses. Now, which ones are they? Humphrey's executor, the Kelo case on the takings clause, Slaughterhouse cases, and then Blaisdell. Pay attention to these. Write these down, and I'm going to ask you: are these ones that Democrats also want to see overturned. Remember, we're answering the question, is there such a thing as a uni-party? Is the uni-party real or not? And, you're going to find out what I think about that. Of course, you already know I'm going to say no, but here, keep going. According to Judge Bybee, a Ninth Circuit senior judge, here he continues again, on changes in the role of the judiciary, restraint versus activism, the Federalist Society. 2 weeks ago, 16 April 2025, we're at minute 47 now.
Wickard and Reich, which are Commerce Clause cases. That's Wickard versus Filburn. Number 6, Shannon mentioned, that would be Miranda and Dickerson.
Wow, he went through those pretty quickly. Okay, let's do Wickard versus Filburn again. What was that, 1941? Something like that. Um, that I think is pretty safe to say, expanded the Commerce Clause beyond anything that any of the framers of the Constitution ever thought was possible. Basically, it took all restraints off of Congress and said, Congress, you can do whatever the heck you want to do under the Commerce Clause. And, you could just make stuff up and call it commerce. That's not really too far from obvious, I don't think. But so there's Wickard, and then he said Miranda was number 6. And you're thinking, gosh, Miranda, isn't that like civil rights for criminal defendants? Well, there's more to the story on that one. You might want to stay tuned. But again, we're answering the question, is there a uni-party? That's what we're asking. So this is one aspect, the judiciary, and let's keep going, according to Judge Bybee. Keep going.
The exclusionary rule. Number 7, one that probably is in the sights of this Supreme Court, would be an Employment Division versus Smith. Number 8 on my list is Bivens. Number 9, New York Times versus Sullivan, First Amendment case. Number 10, Plyler versus Doe, dealing with the education of non-citizen children. Number 11, just for kicks, NFIB versus Sebelius, the Commerce Clause in the ACA. Now, not all of those would be dramatic changes. Some of them would be more temporary. There would be legislative fixes for some of those. But some of those, particularly in the case of something like Slaughterhouse, would be a wholesale reorganization of the Constitution.
All right. So, did you get those last ones? Remember, we're answering the question, is there a uni-party? Yes or no? Let's continue with Judge Bybee, and we want to thank the Federalist Society. Thank you so much, Federalist Society, for making this material available. Thank you. We really appreciate it. We're making a fair use of this material, but thanks for making it available and for permission to use it.
Trying to restore its original intent. Now, that's sort of the conservative side that's the conservative list.
Okay, Judge Bybee, I would push back on that, and I would say that's the Republican side. The Republican side. Okay. Now, what do the Democrats want to overturn?
What would be on the liberals list? Well, at the top of the list would be Dobbs. And you can imagine the destabilization of both the court and our feelings about the idea of a constitution being a kind of meta law by which we are constituted if a more generous liberal court were to come back and reinvigorate a more refined version of Roe and simply overrule Dobbs. Number 2 on the list, Heller and Bruen. Number 3, Citizens United.
Okay, wow, he just went through 3. Dobbs, which is the abortion, overturning Roe versus Wade. 2, Bruen, which is overturning basically an entire ban on public bearing of arms in direct violation of the Constitution. Number 3 was Citizens United, which was a pretty close case about the First Amendment and money being used as speech in campaigns. So there's 3 that Democrats would want to overturn. So far, there's no overlap. And so far, I don't see any support for the theory that there's a uni-party here. Let's keep going and let's hear what the rest of Judge Bybee has to say about this.
Number 4, Shelby County. Number 5, I've got Trump versus United States, dealing with presidential immunity. 6, Students for Fair Admissions. 7, Gregg versus Georgia, dealing with the death penalty. 8.
Okay. Wow, that was a lot there. Number four was Shelby County. Number five was Trump versus United States, I think, on presidential immunity. Number six, Shelby County was a Voting Rights Act case that occurred fairly recently under Chief Justice Roberts, basically saying that the Voting Rights Act pre-clearance requirements from over a half century ago doesn't really apply anymore to some of these Republican areas because Democrats were in control when uh, you know they wanted to keep black people from voting. Um, the Democrats started the Klan. Now Republicans have taken over a lot of these parts of the South, and you don't have to worry about that anymore. Um, and what was number six again?
8, students ruin. Number 3, Citizens United States, dealing with presidential immunity. 6, students for fair admission.
Students for Fair Admissions was the Harvard case. Remember about racial discrimination? That was like just recently, like in the last few couple years.
7, Gregg versus Georgia, dealing with the death penalty. 8,
All right, so they're against the death penalty, Gregg versus Georgia.
8, Agassini versus Felton to reinvigorate the Establishment Clause. Number 9, Burwell versus Hobby Lobby, which would change the free exercise clause. Number 10, qualified immunity.
All right, so I mean, look at the
11,
last one wasn't really a case. Qualified immunity, that's just a topic.
just for kicks, Trump versus Anderson probably doesn't have much application, but I just threw it on the list for laughs, which I didn't get much. That's okay. I'm all right with that. There are a number of decisions that sound in substantive due process that probably are not on the chopping block. There is probably not enough political will to attack these, even if they.
So then he goes in to talk about some controversial cases he doesn't think are on the chopping block. Um, let's get one of those on there. I think maybe it'd be interesting for you.
Rest on shaky constitutional grounds. The first one I put on here would be Obergefell. The second.
Yeah. Okay. We'll leave it at that. We don't want to get too far into the weeds on some of these other cases where there might be some agreement for practical purposes not to overturn them. But you have 10 major issues that, and did you notice abortion came up twice for the Democrats? The first one was abortion. The second one was guns, according to Judge Bybee, and the 10th one or the ninth one, I think, was the Burwell versus Hobby Lobby about the free exercise of religion. That's squarely opposed to abortion. In other words, the contraceptive mandate, which is interpreted as abortifacient. So you have the free exercise clause, you have the establishment clause. I think that was number 8. I can't remember which case it was. Which case was it? The establishment clause. Let's take a look.
Presidential immunity. 6, students for fair admissions. 7, Gregg versus Georgia, dealing with the death penalty. 8, Agassini versus Felton to reinvigorate the Establishment Clause.
Okay, Agassini versus Felton. Okay. That was the establish. So you have First Amendment issues, you have abortion, 14th Amendment issues, you've got the Second Amendment major issues, and then the Republicans are concerned about the contract clause, the commerce clause, too much power for the government. They're concerned about the Warren Court's redefinition of the role of police and the flexibility with which states have under the police power, the traditional police power, to enforce the law, the criminal law. So this whole thing about Miranda, Miranda was, the most famous thing that came out of that case is the so-called Miranda warning that has to be read. And that's basically something that the Supreme Court created and ordered everybody to do from here on out. And so, we could have discussions about all these cases and it would be great to get into it. But you'll notice that the Republican Professor podcast is structured along a lot of these lines. In other words, holding the line, moving forward into a greater understanding of these fault lines between Republicans and Democrats in contemporary American politics. Did you notice that? I mean, the very last episode I did was going through Judge Bumate's dissent in Duncan versus Bonta on the Second Amendment. There he is right there. That's him right there. And he's on the court with this guy. Now, he's an active judge, so he's not going to weigh in on stuff like that. Bybee can get away with it because he's retired and he can say pretty much whatever he wants, you know. So, um, but I'm really bothered when people say there's a Uni-Party in Washington D.C. How do you explain these fault lines then, which run so deep, and why there would be such bitter opposition on these lines? How do you explain that then if there's a Uni-Party? I mean, explain it to me like I'm a really smart 8-year-old. Thanks for joining me on the Republican Professor podcast. It's 1 May 2025, years after Jesus. We'll see you next time.